morning students, myself Diksha Taneja, Assistant Professor, Rama University. My topic today which I am going to deal is ResJeste. Let us come up to the topic first. So, first of all I am going to tell about Bharatiya Sakshi Adhiniyam, Indian Evidence Act which was there in earlier. Right now it is Bharatiya Sakshi Adhiniyam, as all you know. It is there in 2023. It has replaced Indian Evidence Act just because it wanted to have a more simpler legal framework, as well as it had to end the colonial system. So, why was it replaced? Because colonial language was very outdated, as well as we needed tech friendly something. Evidentiary rules had to be simplified, as well as judicial efficiency. Same things. Coming on to the main structure which I am going to deal today, that is chapter 2, relevancy of fact. So, students, there are two different things, relevancy and admissibility. Okay. So, today what I am going to deal is chapter 2. Chapter 2 deals with the relevancy of facts. The very first section is from section 4 to section 29. Now, I would like section 3 is something which I am going to deal with. Evidence may be given of facts in issue and relevant facts. Which facts do we talk about basically? You know, you are not going to come and say anything and say that the court has to deal with it. No, it should be relevant. Relevant in the sense it should be connected to the case. It should be something which is relevant enough for the court to deal with it, right. I will deal with this in the form of an illustration. What does the illustration says? A is tried for the murder of B by beating him. The fact that A caused B's death by beating him is a fact and issue. So, what is a fact and issue? Fact is an issue is like when two parties are there, one party asserts something and the next party denies something. That is fact and issue. Now, that is the issue basically, right. I am saying something, the other party is saying denying on it. So, the issue comes. Okay. The fact that A was seen near the place of the murder, that A had a motive, or A was seen washing bloodstains off his clothes are relevant facts. What was the issue? Whether A has killed B or not, fine, because A said I did not and the proofs were saying that you did. One party is asserting, the second party is denying, right. Now, what will be the relevant fact? Any fact which is related to the situation, any fact which is related to the circumstance, that is relevant. As example, it had motive, or he was seen washing the bloodstains, or he was near the crime scene, fine. Next, this is a very important section students, it is ResJeste. What is basically ResJeste? If you just open your barracks, you will not be able to find the word ResJeste as it is written. But I would tell you what is basically ResJeste. ResJeste is something, what does it say? Facts forming part of the same transaction are relevant whether they occur at the same time, place or not. It was earlier as section 6 and right now it is section 4, fine. So, ResJeste basically is an exception to the hearsay evidence. Coming on to the hearsay evidence is basically something which you have just heard and it has not been seen by you, fine. This is an exception to it. ResJeste basically says if in the same transaction, anything is happening and a bystander, a person standing nearby, a person moving from there has heard something, then that is a relevant fact, whether the person has seen the incident or not seen the incident. If in the same transaction, for an example I am going to tell you, just as an example, a bus fell from the cliff, fine, some of them were coming up and shouting and saying, Ram pushed the bus, fine. I was standing there, I heard them stating, Ram pushed the bus. That was in the same transaction. My statement, when I will go to the court and tell that I heard it, it is a hearsay evidence which is not admissible actually, but this would be an exception. My statement would be admissible under section 4 stating that I saw the same transaction. While the bus was there, the injuries were happening, the people were coming up, I saw the incident, fine. So, illustration, A is accused of the murder of B by beating him. Whatever was said or done by B or A or the bystanders, see these two are the parties, but bystanders also, so shortly before it or after as to the same transaction is a relevant fact. Same thing, even the bystanders, the bystanders are there, their also statements would be relevant, fine. Some of the very famous cases in it, I will start with the last one, that is R versus Beckingfield. What were the facts? A woman came out of a room with a cut throat and said, see what Bedingfield has done to me. So, the two people were there. The guy slit the throat of the girl, and the girl came out of the room stating, see what he has done to me, see what, and she was holding the neck, and she came out and said, see what he has done to me, see what he has done to me. The court excluded the statement, saying it was made after the act, not during it. So this was the time where the judges, the Lord judges, they said that the court excluded. They said the transaction is finished. The girl came out of the room, transaction finished. Shows the limitation of res geste, but later it was the same transaction, the word, it was interpreted in a broader version. Fine. After this case only, this was interpreted in a broader version, stating that even before the transaction, during the transaction, and shortly after the transaction, there has to be no cut in between. You know, you should not have the time to think and fabricate the truth. Okay. Next case, Sukhar versus State of UP. What were the facts? The witness arrived at the scene immediately after the crime and heard the victim naming the assailant. Same as the bus example. Okay. So now what was the held? The statement made by the victim was part of the same transaction and admissible under res geste. Same example of the bus which I stated. Next, Ratan Singh versus State of Himachal Pradesh. Statements made by a child, dying child immediately after being injured. Same thing. Held even though the statements were not formally recorded. Dying declaration has a proper rule. Dying declaration has to be recorded properly, but still, as the person, the statement was there, he was after being injured, this was accepted. Fine. Next cases are, see, there are a lot of sections in this. We are just going to deal 2 to 3 sections right now. The next section is section 5, facts which are occasion, cause or effect of the fact in issue. The Bare Act says itself, facts which are occasion, which are causing any occasion or any cause or any effect, immediate or otherwise, of relevant facts or facts in issue, or which constitute the state of things under which they happen or which afford an opportunity for their occurrence on transaction are irrelevant. As simple as that, any fact due to which any cause is done, any effect is done, any occasion has been made will all be relevant. Fine. I will explain this further with the illustrations. The question is whether A robbed B. Fact and issue is whether A robbed B. The facts that shortly before the robbery, B went to a fair with money and was found injured and without money soon after are relevant fact. Occasion, fine. Next, the question is whether A murdered B. Marks on the ground produced by a struggle at or near the place where B's body was found are relevant. Effect. 2 case laws I am going to deal over there. Lakshman Sahu versus State of Bihar, AIR 1979. What are the facts? The accused had threatened the deceased a few days before the murder. See, motive, fine. Held, the threat was relevant as was the cause and motive behind the murder. You can see the cause because he is threatened, so the cause. Next, Mogilal Chunilal Pandya versus State of Bombay. The accused was arrested near the scene with bloodstains and a weapon shortly after the murder. See, effect, right? The presence of the accused near the scene and the recovery of bloodstains was the fact showing the effect. Fine. Next is section 6. Section 6 deals with 3 things. Motive, preparation and conduct. This is also a very broad topic. Motive itself is something big, preparation you all know, and conduct is also something different. Motive. Why did you do this act? What were the steps you took before doing the act? Conduct. What is your behavior before or after the crime? Section 6 illustrations. A tried for the murder of B. This is the fact and issue. The facts that A had the motive to kill B, maybe he is insulted or any XYZ reason, and that A purchased a knife days before the murder. Motive also, preparation also. He had the motive, he did the preparation by getting a knife, fine. So, next, A is tried for theft of property. The fact that immediately after the theft, A was found in possession of the stolen property or attempted to flee. Attempted to flee, he tried to run away from there, that is a conduct. Case laws. The first case law, State of Maharashtra versus Damu, AIR 2000, the accused was charged with the murder of his wife. Before the murder, he was found to have purchased poison. Preparation. Okay, this is preparation. Next, Akash Chand versus State, The accused tried to run away when approached by police shortly after the crime. Conduct, subsequent conduct. When you did something wrong, you were approached, you ran away, and that was your conduct, relevant conduct under section 8. Next, State of Rajasthan versus Kashiram. The accused was charged with rape and murder. The prosecution brought evidence that the accused has been seen loitering around the victim's house before the crime and threatened the victim. Preparation. So, what is the importance of these 3 sections? These are the foundational sections. These hold a very high evidentiary values. As I have already stated, ResJeste is an exception to the hearsay rule. Hearsay rule in our Evidence Act, in the Bharatiya Sakshi Adhiniyam, says nothing which is just heard by you will be admissible. Nothing. Fine. You need to see, you need to be present at the crime scene, or anything. You should have been seen with your own eyes. But ResJeste is a clear exception to it. Some case laws, Queen versus Emperor, a dying declaration was made by the deceased just before dying, same as I talked about. Then the next was State of Uttar Pradesh versus Rajesh Gautam. A person was murdered, and during the incident the deceased simultaneously took his name. Same thing. Misinterpretations. ResJeste is not any nearby event, it has to be the same transaction. ResJeste is basically has to be in the same transaction of the same crime. You cannot take the plea of being here and there. ResJeste simply says any crime, anything, any act which is done nearby or nearby from the same transaction, the crime should be same, the people can be from anywhere. A can be in Pune, B can be in Lucknow, but they can still form the same thing, they can still form the same loop, and all acts done under that would be relevant under different sections. These are important sections, they provide clearer understanding and judicial utility. Thank you so much.